Y'all, please bear with me. This video is going to be a little bit lengthy, but you're going to want to watch it to the end. Trucking community, I want you to meet Ally Logistics. Ally Logistics, meet the trucking community. This is a carrier agreement, okay? And this is my public service announcement to all fellow carriers and truck owners, because I am a truck owner. Now, I'm going to go down to page 11 and show you a clause in this contract. And this is the kind of stuff that these brokers have attorneys that write the contracts. They know the average man or woman out there are not sophisticated in contracts. Sophisticated means you're an expert. Most people think they are an expert because they can read them, but they don't think about the logical ramifications and can that contract be enforced under the law? So let's go to page 11. This clause right here, waiver of rights pursuant to 49 U.S.C. 14101B, to the extent that such rights or remedies conflict with the terms and conditions of this agreement, carrier hereby expressly waives any rights and remedies available to carrier under 1 state, 2 federal, 3 common law, or number 4 under 49 U.S.C. subtitle 4 part B. Now, let's go look at what the law says. This right here is 14101, okay? Subpart B, in general, a carrier providing transportation or service subject to jurisdiction under Chapter 135 may enter into a contract with shipper other than for the movement of household goods described in Section 13102-10A. Okay, now, to provide specified services under specified rates and conditions. If the shipper and carrier, yes, it says shipper and carrier, but the courts have already construed it to mean broker and carrier also. Here's why. You have to understand the law of agency. The broker is acting as an agent on behalf of the shipper, so yes, it can apply to broker and carrier also. Expressly waive any or all rights and remedies under this part for the transportation covered by the contract. The transportation provided under the contract shall not be subject to the waived rights and remedies and may not be subsequently challenged on the ground that it violates the waived rights and remedies. The parties may not waive the provisions governing registration, insurance, or safety fitness. So, I would have to go into a deeper video on how this applies later, okay? But it says remedy for breach of contract. That they only put the 14101B. They don't tell you remedy. The exclusive remedy for any and all breach of a contract entered into under this subsection shall be an action in the appropriate state court or United States District Court unless the parties otherwise agree. That means what? They have to leave you a way to get remedy. They have to. They can make you waive certain things. They cannot make you waive everything. Watch. Now watch this. This is the AI-assisted research on Westlaw. It's highly accurate because it's a closed system. First, you would need to understand what the contract is. It's an adhesion contract. What is the elements of an adhesion contract? Standardized form, aka template. They use the same standardized contract for every single carrier. Okay? An adhesion contract is characterized by its standardized form, meaning it is prepared by one party without negotiation. You never had a chance to negotiate the terms of that contract when they prepared it. They had some law firm prepare the contract. Nobody else was there, and this is a standardized form. Inequality of bargaining power. The contract is offered to the weaker party. You are the weaker party. You have to come to them. Now, weaker doesn't mean strength, so don't think stronger and weaker has to do with how big your muscles are. They don't. The contract is offered to the weaker party who generally has no realistic choice but to accept the terms as they are presented. This often results in a significant imbalance in bargaining power between the parties. It absolutely does. We know the broker rates are terrible, and these brokers are out there saying that we need them. Well, you need some. I'm not going to say we don't need any of them, but yeah. But the problem is the brokers are being greedy. You got some brokers in here defending their position, saying they're not. They are. The contract is submitted on a take-it-or-leave-it basis. Further emphasis, the lack of negotiation and choice of the weaker party. In other words, if you either agree to this or you won't do business. Okay? That's what is required. That's the elements of an adhesion contract. What they want you to think is this right here. A waiver clause citing, you can read this section here. All I did was copy it from the contract. That expressly waives the carrier's rights and remedies under state, federal, common law, and 49 U.S.C. Subtitle 4, Part B, can be enforceable to prevent the carrier from pursuing remedies in case of a breach of contract by the broker. Now, pay attention to the language, can be. Doesn't mean it is. Okay? But read this section. I asked the question, but would this clause in the contract not be against public policy? It forces the carrier to agree and waive all remedies that are there. And in any adhesion contract, there has to be an avenue for some kind of remedy. It says a waiver clause in an adhesion contract that requires a carrier to waive all state, federal, common law, and statutory rights and remedies, including those under 49 U.S.C. Subtitle 4, Part B, is likely void as against public policy. Adhesion contracts must preserve some avenue for remedy, and provisions that impose unreasonably burdensome costs or have substantial deterrent effect on a person seeking to enforce and vindicate rights and protections are considered unconscionable unless exceptional circumstances exist. There would never be an exceptional circumstance in a carrier agreement for you to waive every possible right. Yes, they can do it to where if you agree that you have to go to a specific court, be it a state court, be it a United States District Court, or some places use what's called arbitration. They cannot make you waive every right. The contract would be considered voidable. I put this out there because why? Y'all truckers and the people at large, you need to start learning how the game is played. It's not a bad game. They just know that the American people don't know the rules. Remember, the judge is a fact finder. If you don't give the judge the proper facts, he can't make an adjudication on the way you want. And trust me, these attorneys know this. You just don't know this. So, take this video for what it is. It's just a PSA for the trucking community and an example for the people at large. Y'all have a wonderful day. God bless. I'll do this again later.